If you're a Chicago tenant facing eviction, you may want to know what to expect on your court date. My name is Michael Van Zalingen. I'm an Illinois attorney, and I help Chicago tenants take control of their evictions so they can protect themselves and their families. The first thing to know is that the court call takes a long time. So if your summons says be at court at 9:30, you're probably not going to step up in front of the judge until 10, 10:30, maybe even 11:30, depending on how busy the day is. So be prepared to wait. Get off work for the whole morning. Also, the court does provide child care from 8:30 to 4:30 in room 1319 of the Daily Center. The second thing to know is that the eviction process is slightly stacked against the tenant. The judges are very fair and they're not prejudiced against tenants, but the system is designed to expedite you through the process from the case being filed to the eviction. In a normal situation, you get lots of time. In evictions, the legislature wants you to move out quickly. Number 3, many tenants have good defenses that either defeat the landlord's claim entirely and you win the case, or reduce the amount of money that you may owe the landlord, or will motivate the landlord to enter a pay and stay agreement with you, or agree to give you reasonable time for a dignified exit. The challenge is that these are technical defenses that must be set forward just so. That's why it's very important to talk to an eviction attorney who knows how to set those defenses up. Otherwise, you risk losing them if you try and present them yourself. Number 4, your court date is presumed to be your trial date. Now that's a problem because you probably just found out about your court date a week ago. So the judges are pretty generous about giving short continuances to get your witnesses ready, gather documents, hire or consult with an attorney. All you have to do is ask. They'll usually give you a 1 to 2 week continuance to get it together. Lastly, number 5, if you lose your case and an order for possession, an eviction order is entered, that doesn't mean that the day the judge orders you out, the landlord can go change the locks. That's not how it works. An order for possession is an order to the sheriff to put you out. The sheriff has a backlog. Nobody knows exactly how long, but when you get an order for possession entered against you, it only means that the landlord can take that order to the sheriff, and then they have to wait for the sheriff's backlog. The landlord can't just change the locks on you or set you out after a week or 2 weeks. So don't panic. You still have a little bit extra time to work something out.